Just hours before this man was due to be put to death, a U.S. state Supreme Court halts his execution. The FBI has raised doubts over evidence presented to convict him. What does this case reveal about capital punishment in the United States? You're watching Inside Story Americas from Washington. Hello, I'm Kimberly Helkett. Convicted of murdering two white students in 1994, Willie Manning was sentenced to death. His execution was to be carried out on Tuesday evening. But at the 11th hour, the Mississippi Supreme Court stepped in and blocked it. The court did not give a reason for its decision. However, doubts over the evidence used to convict Manning have been piling up. The U.S. Department of Justice recently sent several letters saying parts of testimonies given by two FBI experts were erroneous. The FBI has even offered to conduct DNA tests, an offer which was rejected by Mississippi's Attorney General. Well, the case has once again raised concerns and questions over capital punishment in the U.S. And while 18 states have abolished the penalty, 32 have not. And in Florida, legislators are trying to pass a law that would make it more difficult for inmates to appeal their case, speeding up their road to execution. Well, later in the show, we will be talking to a former Florida death row inmate who was exonerated just last year. But first, I spoke to Willie Manning's attorney from Jackson, Mississippi, and asked him why he thinks the court decided to stay the execution.
We think it was stayed because of letters that had been received from the Department of Justice over the past 5 days, calling the expert testimony into question. Not just calling it into question, but alleging that the testimony was invalid.
Talk to me a little bit about that testimony, which was part of the evidence in this case that led to a conviction. Talk about the strength of the evidence.
One, an FBI analyst testified that he examined some hair fibers taken from one of the victim's car, and that he was able to say that those fibers came from an individual of the black race. The letter from the Department of Justice and the FBI that we received on Saturday said that that was an error, so that exceeded the bounds of science.
So what you're suggesting then is this evidence was not in any way conclusive?
No, not at all. But the expert testified conclusively that the hair came from an individual of the black race. And according to the FBI, the science doesn't allow him to say that based merely on microscopic analysis.
So do you think that the burden of proof was clear-cut in this case, or are there questions that, in fact, this case should be retried?
There are numerous questions. Questions about the expert testimony regarding the hair is just one question. The next question is some ballistics testimony. An FBI expert testified that bullets taken from a tree in Manning's yard were fired from the same weapon as the bullets that killed the victims. A letter from the FBI that we received Monday evening at 7:30, the evening before the execution was scheduled to take place, said that that expert testified erroneously, that he is not able to say with that level of certainty that those bullets came from the same gun. The expert exaggerated his conclusion by saying that he could match those bullets to the same weapon to the exclusion of every other firearm in the world. That's a direct quote from his testimony, and according to the FBI, that exceeded the bounds of science.
Now, when you talk about science, the FBI, in fact, offered to conduct DNA tests on some of this evidence, and it was rejected by the Mississippi Attorney General. Why do you think that was the case?
I don't know why that was the case. But for some reason, the Attorney General insisted on pressing ahead with the execution in spite of these letters that we had received from the Department of Justice calling two major pieces of testimony into question.
What happens now in this case?
We aren't sure. We don't know for example, even how long the period of stay will last. The Mississippi Supreme Court has to tell us what we are allowed to do and what we must do during the period of the stay. We hope that they will allow us to conduct DNA testing, but we don't know that yet.
Well, joining us now for more from Miami is Stephen Harper. He is a law professor at Florida International University and has represented many prisoners facing the death penalty. In our studio here in Washington, we have Richard Dieter, Executive Director of the Death Penalty Information Center and a law professor at Catholic University. And we also have Bruce Fein, a constitutional lawyer and former U.S. Associate Deputy Attorney General under President Ronald Reagan. Richard Dieter, I'd like to start with you. How surprising is it that the Mississippi Supreme Court would stay the execution of Willie Manning?
Well, they had voted not to stay it just a couple days earlier, so it was somewhat surprising. But on the other hand, this is an unprecedented case, with the Justice Department sending the state of Mississippi 3 letters saying we erred in this case. I think they had to grant a stay, and the eventual vote was 8-1, so it was pretty strong when it finally happened.
How significant is it that Willie Manning is black and the victims were white? I mean, how significant is the fact of race in this case?
And that this case was in Mississippi. I mean, you know, race enters into these cases. This is a 20-year-old case, but the FBI was testifying that, in fact, they had found a black person's hair at the scene of the crime. Wow. And here you have a black defendant and white victims. I mean, it adds to the credibility of the conviction of the state's case that we have the right person. Take away some of those pieces of evidence, and then the conviction doesn't look so strong. So it's in a way not necessarily black and white, but it added to the sense that no reasonable doubt he's the right person.
How prevalent is that kind of a concern or question when it comes to evidence and cases? Is it just Mississippi, or I guess what I'm asking is how illustrative the Manning case is when it comes to other death penalty cases in the United States?
Well, to have last-minute appeals, of course, is not unusual. What's unusual here is how much scientific evidence was either untested or had been testified to invalidly. I mean, and all of this is, you know, reaching a crescendo and a few hours before his execution. All of that is unusual. The elements of race, I mean, this was also a case in which certain jurors were dismissed, not allowed to serve, and more of them were African-American jurors. That kind of thing happens quite often, and the Supreme Court of the United States has said, you know, that has got to stop, but it can continue in subtle ways.
Stephen Harper, I want to bring you into this discussion. I mean, with so many questions about evidence, whether it be Mississippi or other U.S. states, should there be a higher burden of proof for death sentence or death penalty cases and convictions?
Well, I think the only higher burden of proof can be to get rid of the death penalty. And I say that because there have been 24 people in Florida alone that have been who were on death row and they were exonerated. The system that we have, the justice system, is full of imperfections. And if they convict somebody of armed robbery or grand theft, that's one thing. But to execute a person is another thing. So I think, and I say this is professionally, I don't think that the death penalty can survive because the human error is just simply too great. And there's no place where that's more obvious than Florida.
And we're going to look at the numbers and look at Florida specifically. But Bruce Fein, I just want to talk to you for a second. You know, given the fact that there have been so many examples, as Stephen Harper cited there, is this one reason to at least consider that there should perhaps be a moratorium on death penalty sentences?
I don't know whether the moratorium is the rule. I'm not so sure I would agree with the professor that you cannot articulate a higher standard with particular evidentiary rules, such as DNA proof that would eliminate any certainty at all, or anything that maybe to a moral certainty that the person is innocent. And I think of, for example, when I was young, saw Jack Ruby kill Lee Harvey Oswald with a gun on television. There are instances where crimes are committed and there isn't any real doubt as to what happened.
But
and
that's
surely
a very rare
No, I understand, but we're
situation.
talking here about whether the death penalty should be preserved in any circumstance whatsoever. I think that's what we're addressing. Or like, is there any doubt that genocide was perpetrated by Adolf Hitler and Hermann Goering or whatever, or that Adolf Eichmann was complicit in perhaps 6 million deaths? And I do think it's important to consider these extreme cases if you're going to reserve the death penalty for actions that we find totally and completely morally reprehensible, almost nauseating from someone who's compos mentis, and think it's just outrageous that someone who has committed killings of 6 million gets the same sentence as someone who may have committed one homicide or a rape or something of that sort.
Well, as Stephen Harper mentioned, you know, there have been a large number of exonerations in the United States. I want to look at some of those numbers. From 1973 to 2012, 142 people sentenced to death have been exonerated in 26 different U.S. states. 12 people have been exonerated in Texas, the state that accounts for nearly 1 in 3 executions since 1976. 20 death row inmates have been found innocent in Illinois, where the death penalty was abolished in 2011. And topping the list is Florida, where 24 people have been exonerated. That's 1 out of every 6 exonerations in the United States. Now, despite its record, last month, Florida's legislature, in fact, passed a law that would speed up executions in the state. The bill still needs to be approved by the state's governor, Rick Scott. Former Florida death row inmate Seth Penalver was recently exonerated after spending 18 years in prison. Now, he went through 3 trials facing charges for the murder of 3 people in 1994. After the first trial was thrown out, he was convicted and sentenced to death at the second trial, but his last appeal ended in his exoneration. Well, he gave me his reaction after the jury announced his acquittal.
I still couldn't believe it. You know, I heard the words, and if you actually look at the video, I begin to rub my head and in amazement, you know, to see if this is real, because I had many dreams, you know, while in the county jail and on death row, that I was free just to turn over to the side and maybe hit my arm on the wall and to wake up. And I thought maybe this was that dream, and I just was rubbing my head and like, you know, is it real? And when I finally, you know, it clicked in when they, you know, went to, like, I believe it was count 3, you know, all 3 counts of first-degree murder, not guilty. I had 6 counts in total. The other 2 were, the other 3 was armed robbery, armed burglary, and attempted robbery. And when they got to 3, I was like in amazement. I dropped to my knees and I prayed. And still to this day, even when I'm outside, you know, and I maybe see the beach, something beautiful, you know, and I ask myself still to this day, is this real? Is this a dream? Am I going to wake up?
Now, the state of Florida, where you're living and where you were incarcerated, is now actually trying to put in place a law that would speed up the process. So while you spent 6 years on death row, in the future, if this proposal becomes law, inmates would spend even less time there. What is your reaction to that if that does become law?
My reaction to it was, it blew me away, because it's almost like I dodged a bullet. You know, if God forbid, I was still there and this law would have came to effect, me actually coming to death row on a new sentence, I'd probably be dead. I wouldn't be talking to you guys out there right now. You know, I found the evidence along with a private investigator and a paralegal of mine that was on our defense team. We found this evidence, and it wasn't, the evidence wasn't given to us by the state of Florida or by the law enforcement community, Miramar Police Department. They didn't give this to us. We found it by, you know, hard work. It took me 18 years to uncover that. And my fear is, what happens to others that are sentenced to death that may be innocent? And usually in the state of Florida and throughout the United States, you know, a claim of innocence or evidence that's been hidden doesn't come to light in 2 or 3 years after your conviction. It's sometimes decades upon decades later, you know, and my fear is that we will be executing an innocent man. The state of Florida, by passing this bill, is trying to actually cover up the amount of people that are getting exonerated in the state of Florida. We lead the nation in the most exonerees in the United States. Every 3 executions, you have 1 exoneree. Something is wrong with that picture. There's something really wrong with that picture here in the state of Florida. And by speeding it up, we definitely, without a shadow of a doubt, we will be executing an innocent man or innocent woman that is sitting on death row.
Well, that was former death row inmate Seth Penalver. He is now a part of Witness to Innocence, an organization composed of exonerated death row inmates. Stephen Harper, I want to ask you about that law that Seth Penalver is referencing there. How is Florida trying to speed up executions? What does this law that has not yet been signed into law, I should point out, but what does this propose to do?
What it proposes to do is to, if somebody has gone through what they call the clemency process, in other words, should the governor pardon them or commute the sentence, and the Supreme Court of Florida sends a message or sends a note to the governor that all of their legal remedies have been exhausted, they are then eligible for execution, and it says the governor shall sign a death warrant within 20 days. And so that's the concern, that there are at least 13 people, according to the sponsor of the bill himself, Matt Gaetz. There are at least 13 people who would be immediately subject to execution here in Florida. And as was pointed out, it would reduce the amount of time that people are on death row, and that time is critical to determine whether people are innocent. And I think it's very important that people realize that. Innocent people will indeed be executed in Florida.
I think the argument, though, in the Florida State Senate is that the victims' families and their rights to seeing swift justice actually supersede an inmate's right to seeing a fair trial or seeing sort of the due process played out. Here's a sample of just some of the arguments made in favor of the Florida bill. Now, Republican Senator Rob Bradley said, quote, "When someone sits on death row for 10, 20, 30 years, it really makes a mockery of our justice system. It's not fair to the victims' families, not only to be traumatized by the loss of a loved one, but then to have to sit and suffer while justice is not realized year after year after year." He went on, "This is not about guilt or innocence, it's just about timely justice." Another Republican who sponsored the bill in the lower house, Matt Gaetz, said, quote, "Only God can judge, but we can sure set up the meeting." I want to talk to you a little bit, Bruce Fine, about this. I mean, is swift justice always fair justice?
Of course not, and it really is an odd comment to make. The fact that we permit many procedural safeguards, even if they're not flawless, is testimony that we don't want to execute someone who's innocent. We find that morally reprehensible. So the fact that there's delay is a reason to applaud and not to decry. Moreover, the law does not recognize a right to a family of a victim, to push justice on an accelerated basis. It is true that typically they're wrongful death, they're civil remedies. We found that in the O.J. Simpson case, where the families of the deceased then brought a civil suit, recovered damages. But when it comes to criminal punishment, it is the policy of the state that governs, not the private citizens who may feel in turmoil. Some would not. As we experienced in the Zacharias Moussaoui case, and he was convicted of 3,000 murders relating to the 9/11 abominations, the families, the victims, were quite divided. Some said, we don't want the death penalty. Others said they did want the death penalty. The jury decided, no, they were going to give life imprisonment. But we don't permit subcontracting our judgment as to what's an appropriate penalty to families or private citizens.
Do you see any concerns?
Let me just interrupt
sure.
a second. That's a very good point, because I think that the members of the House and the Senate in Florida assume or presume that all victims' families feel the same way. And as was just pointed out, victims' families feel a variety of different feelings, and many of them don't want to see the person executed, and many of them want to get the case over with as soon as possible so they can move on. There are some that want to see the person die, but there is not a uniform understanding on the part of victims that this is the only way to go.
So Richard Dieter, where does public opinion in the United States stand on this issue?
Well, generally, most of the people support the death penalty in theory. But when it comes to the death penalty in practice, like what about these mistakes? What about the unfairness? What about the costs of the death penalty? You get a different reaction, and you get more people supporting life without parole than the death penalty in some of these polls. If it's just a philosophical question, people don't have a moral objection to the death penalty. But of course, no one wants innocent people executed. No one wants it to be unfair. And so that's why the death penalty in practice is what's considered in the legislatures and in jury rooms, and the death penalty is declining by
but
huge
let me
amounts.
interject here. We may have a trial soon of Khalid Sheikh Mohammed involved in the 9/11 abominations. And my belief is the overwhelming number of Americans believe if he's found guilty and the evidence is not conclusive yet, but is likely, they will want the death penalty.
But that is, again, an extreme case where a lot of resources and a lot of money is going to be poured into trying that case. That's not always the case, is it? I wanted to follow up.
No, it just means that we need to be discriminating, which is exactly, I think, what this program shows. Right now, it's too broad. We need to be more careful and scrupulous.
Is that even possible, I guess is what I'm asking. I mean, how often does poor representation by perhaps public defense attorneys really affect the outcome of these cases?
Yeah, we've got something like 3,100 people on death row. None of them are like the case that was described. None of them are. They're all the ordinary kinds of crimes, and that's where, you know, our humanness comes across. Our mistakes, our biases, our lack of full representation or due process, and you know, that's the problems that we have to address. And some states are saying we don't see how this can be easily fixed. We're getting rid of it. Maryland, New Jersey, Connecticut, Illinois. 6 states in the past 6 years have said, we tried it, it doesn't work.
Stephen Harper?
And I think those states, the major reason why those states did it is because they could not figure out a way to protect the innocent people from being executed. And I agree that many states are moving in the opposite direction. And part of that is also because the lawyering that goes on is not, it's generally very bad here in Florida. In fact, I used to work in the public defender's office. I now work at the university because I'm starting a clinic to have students work on cases to show lawyers how it can be, how mitigation can be presented, how they can get the money in order to present the mitigation, because a jury has to know prior to making its decision whether to execute or to kill or not to kill, a full history of this person. And those resources, and that the lawyers are not doing, and they don't have the resources, and they don't have the understanding of what's involved. And that creates a real problem, because many of the cases where people are on death row, they wouldn't be there if the jury was fully informed.
I think that the federal standard, and you've omitted, the federal government does have a death penalty as an option for the jury, does set a standard that shows that you can make these kinds of distinctions. For example, the youth now who's eligible for the death penalty for participating allegedly in the Boston Marathon bombings has a special death penalty expert that was brought in as a lawyer to defend him. It is true there are countless Supreme Court decisions that require a great deal of expertise to be an adequate defense attorney in capital cases. But that just means, it seems to me, the states and the federal government have to be willing to spend the money so that we don't have second-class lawyering in these kinds of cases. Otherwise, the death penalty, in my judgment, should be ruled out. The penalty is too harsh to risk at all any kind of incompetence as leading to an improper sentence.
Richard Dieter, but practically speaking, can states afford to allocate those kind of resources?
You know, they haven't been willing to, that's for sure. I mean, Florida has been pushing to speed up executions, but Florida hasn't even qualified under a federal law that would have sped things up if they had only provided adequate representation. They haven't done that. They haven't met the federal standard, and so they don't get the swifter appeals that they could have gotten. Another problem, though, is, you know, you can spend all your money, and you have a case like Willie Manning that we talked about earlier. I mean, everybody was sort of, the FBI was probably acting in good faith. They said, this is the science, but science changed, and now we know it's wrong. You know, that kind of problem that you might find out 10 years from now that somebody is innocent, that's hard to spend enough money on to eradicate. It's always going to be a problem, and I think it's a fundamental contradiction.
Stephen Harper, last 30 seconds for you then. Is the problem in the U.S. when it comes to the death penalty and capital punishment that the arguments for and against really have become political rather than legal at this point?
I think that's true. I think they've become very political and it's a moral question, but in most people's minds. But as Dick pointed out, if you look at really what's going on and how it's going on, nobody would agree that these people should be killed because they don't have the resources necessary to present their entire lives and what their lives were like. So I think it has become way too political, and that's a problem.
All right, gentlemen, we're going to leave it there. Appreciate you joining us here on Inside Story Americas. That's all from the team in Washington, D.C. Thanks for watching Inside Story Americas.